everybody. Good afternoon. All right. So Mark just said that I'm Kim Chamonpin. I'm the director of the Lawyering Skills Program here at John Marshall. I am also the president-elect of the Legal Writing Institute. Thank you. I wanted to introduce my colleague, Mark Cooney. Mark Cooney and I are the things that are standing between you and a cocktail. So what we plan on doing is making the session a little bit interactive so that you can put into practice a little bit of some of what the rest of our speakers today have been discussing. Mark Cooney is a professor at Thomas M. Cooley Law School, where he teaches in the writing program and directs it. Before joining the faculty, he spent 10 years in private practice in civil litigation, mainly defending professional malpractice cases and other tort cases. Professor Cooney is a member of the board of Scribes and is also the editor-in-chief of the Scribes Journal of Legal Writing, having previously served as an associate director for 4 years. Professor Cooney is a prolific writer, and he is going to be sharing with us some basic writing tips today. So our session today is called Basic Writing Tips, or we might also call not so basic editorial tips that will help you refine your writing so it can be as clear as our awardees this afternoon, Judge Easterbrook and Judge Posner. So just a quick overview. What we'll be doing is just going through some very basic, clear-cut tips set with a lot of different examples so you can all try your hand at 4 different edits, 2 rules that you want to break, plus a punctuation rule. It sounds very exciting, I know. And here is Mark Cooney to help you with the first tip.
Thank you. We'll do this like a basketball game. I'll get tired, and then she'll come in off the bench, and then we'll go back and forth, although notice she was the starter. The great misconception in my mind is that editing, and of course we talk about writing, but editing is such a huge part of it. But we think about editing or many people do, as a function of time. That if you put a piece of writing down on a desk in front of a room full of people and gave them all a half an hour, well, they all have a half an hour, right? So they're going to find the same edits. Not so much. Not so much. When you're fighting for clarity, I love hearing that word clarity from the judges and justices. It's a fight. And I'll tell you, clear writing, clarity, does not fall onto us from the sky. You've got to take it. You've got to earn it. You've got to work and learn edits. You've got to learn the edits. So we've got to think about specific things that we're on the lookout for in our drafts. If you're a clerk for a judge, maybe looking for those edits in your judge's draft. And we have selected 4. And the first one, admittedly, is really more of kind of an attitude, more of an outlook on writing, I admit. The other 3 are very specific edits that you can learn to spot and react to as a writer and improve your draft. So the first one you see is avoid needlessly inflated or wordy language. So let's start with that. Notice, by the way, the word needlessly. Needlessly. Hey, if you're writing about negligent infliction of emotional distress, and one of the elements is that you have to witness the event or arrive fairly contemporaneously. Well, you know what? That's the legal standard. And you have to use the words fairly contemporaneously. You're going to have to tie the facts of your case back to that legal standard. So, of course, you have to use the terms of art. But for everything else, be confident. Connect with your readers. Connect with your readers. Okay? Don't bog your message down with the excess baggage that we see in so much writing. And I'm going to jump back here. There's this idea that somehow little words, ordinary words, are not, they're not sophisticated, they're not beautiful. It's not aesthetically pleasing. And so what I did is I just found a couple of examples. I've got a lot more, believe me, but you do need to get to those cocktails. Of people outside the legal arena talking about what they're looking for in language. and you may be surprised, from a longtime editor for fiction writing, for novelists. Classic language is simple language. I love this. Make yourself almost invisible. When you read some great writing, you're not paying attention to the language. You're so wrapped up in the message that the word choice is almost unnoticeable. That's really what we're striving for in legal writing, where, by the way, in legal writing, what do we know about our reader? By definition, our reader is busy as hell. Our readers are busy as hell, whether it's a judge, a judicial clerk. Clients are busy too. Bosses at the firm are busy. You know, the woman in the corner office that told you she needs that memo, she's busy. She's got a deposition at 3:30 this afternoon. She's got 42 minutes to read your memo. People are busy. Oops. All right, so anybody from Washington, D.C.? Any? All right. So there's a magazine called the Washingtonian, and in their author submission guidelines, they're very upfront about how sophisticated and well-educated their readership is. This is a very pinkies out publication here. We've got the cultural elite. What kind of language do you think those editors want from potential authors? Amen. That's what we should be doing as lawyers. That's what we should be doing as lawyers, right there. Now, non-legal writing, of course, I know you're lawyers to be, or lawyers or judges, but a barn in a day is a small night. The splinters of light between the dry shingles pierce the high roof like stars, and the rafters and cross beams and built-in ladders seem, until your eyes adjust, as mysterious as the branches of a haunted forest. I'm now in my in-laws' barn on a sunny summer afternoon because Updike put me there. And it's delicious. It's fantastic. And 32 of the 45 words were a single syllable. The rest were two syllables, and mysterious is the only longer word than two syllables. And yet he painted a picture. He transported us somewhere, and it was beautiful. It was beautiful writing. Beautiful writing. And dares to claim the sky. Yummy. And dares to claim the sky. You don't need overtly flowery language to make your point. It's about careful word choice, careful editing. You can't set the hook, as Lisa McElroy talked about, without clarity. You can't capture a round character instead of a flat character without clarity. But we can do that with smaller words. Smaller words. Now, here is the typical. If you are a law student, you're probably going to be reading this for homework tonight. So I've highlighted and read, and I guess I'm not saying you should never use the word utilize. It just sounds like a cover letter. It sounds like you're trying to prove something. I don't know. Are there 2 times out of 100 where utilize says something different than use? Now, I don't know about you, but I've never consumed a beer. I drink mine, and they're good. I don't consume my glass of wine with cheese. No, I don't do any consuming. So again, be confident. For law students, this is going to be a tough battle for you because you're going to read all of those old opinions. And you think, well, this is what lawyers are supposed to do. I've got to take on this baggage. You don't have to take on this baggage. Right? Like a human being who happens to be a lawyer. How about after his firing, the employee sued? Lawyers are so afraid of the word sued because they think, well, everybody knows what sued means. I have to say something like commenced a cause of action against. Sued. Maybe telling your reader that somebody sued somebody's important, but usually the reader's eager to get past that to something more Important, like what was the nature of the suit? Roger Clemens sued his former trainer for defamation. There you go. There's nothing unlawyerly about that. Oh, by the way, going back to Lisa McElroy's presentation, what were those words at the entrance to the U.S. Supreme Court again?
Equal justice under the law.
Equal justice under the law, not equal justice pursuant to the law. Okay? Now, I'm in Michigan, and I know for a fact, because I have so many spies, that the Michigan Court of Appeals has these stock things that they put in for the summary. We call it summary disposition in Michigan because evidently summary judgment wasn't good enough for our state. But I know that it says pursuant to, someone moves for summary disposition pursuant to MCR 2.116 sub capital C sub 10. I tell my former students who work for the court, I want you to sneak in there and change that to under. Equal justice under the law. Okay? Again, we can drink beers. That's allowed. Okay? Now it's your turn. Take a look at this, and I would like you, I'm not going to call on anybody, but take a look at this and see if there are any edits that you might make. And then I might ask for a volunteer. For your law students out there, pay no attention to the fact that half of the judiciary in the Midwest is here. Don't be shy. Don't be shy. We're all friends here. Any thoughts? I didn't give you much time. Any thoughts?
Afters.
You had me in after. Beautiful. Great edit. After settlement negotiations. I love it. I love it. Anybody else want to play? I'll go back to this gentleman if nobody else wants. Okay.
The parties agreed.
The parties agreed. Yeah, the parties agreed. What's wrong? There's nothing unlawyerly about saying the parties agreed. It's okay. We can do that. What next? This one I'm not expecting people to necessarily jump at. Before instead of prior to. Now, prior to is not that bad. I have a buddy who calls it a gateway drug. Prior to, he's like, prior to is not that bad, but next thing you know, you're using prior to. Next thing you're at a party and somebody's trying to convince you to try pursuant to and aforementioned. So be careful of prior to. You're going to. Oh, Judge.
No. Instead of making a determination, you have to on whether we decide.
Decide. I love it. I decide. Decide. I love that. Great. Now, here's our little twist that Kim and I came up with. We're going to be honoring Judges Posner and Easterbrook tonight, so why not see how they would have done it? How would they write what we just went over? And here we go. Ready? 1, 2, 3, and exactly what you just told. That's how he would write it. I just pulled up, Kim and I pulled up a couple of cases. It was very easy. One recent opinion from each of the judges gave us all the ammunition we needed for all this stuff. Because their opinions just flow. Their opinions just flow. All right, let's try another one. Oh, well, just a little. Subsequent to becomes after for life, forever. Why use two words to say one word and two words with about 8 gazillion syllables? Risham agreed for, notice that little, before we tackle that subject, I highlighted that. There's nothing wrong with the word addressing. I think that's perfectly fine and very straightforward. But just an example of a little creative word selection there, occasionally, by Judge Easterbrook, before we tackle that subject. It's conversational, as we heard the judges saying a few minutes ago. All right, try again. Fire away. Because is a great word. due to the fact that, for the reason that, become because automatically. Automatic edits for you, because. Dorothy couldn't have sang her song on the Yellow Brick Road using due to the fact that. It just would not. I will not sing it, but she could not have done that. So this takes 31 words, by the way, so let's keep an eye on that. But yes, cannot maintain suit to the, because they have. Now, is there an edit before that we might spot? Yeah. Sue. The sons cannot sue because. Wow. 2 edits. And we are really tightening up the prose here. We are really tightening things up. Any others? The sons cannot sue because. Yeah. There's actually any number once we get past those first 2 big ones. Now, I hope you see this one right there. I almost didn't even put that in because you're not going to write that, are you? You're not going to actually do that. Said this, said that. I still remember seeing Brian Garner speak in 1998, and he was talking about don't write anything that you wouldn't say. And his example was hey, honey, thanks so much for making breakfast this morning. I really enjoyed said meal. And it's 1998 and it's still here. There's not much else, but that's in there, by gosh. So we've got a number of possibilities. Let's see how Judge Posner would rewrite that passage. The sons cannot sue because they admit. There's a little tense change there. He changed, and it's grammatical, of course. You'd have to be careful about that. But because they admit in their complaints that they failed to sue within 6 months, and we're down to 18 words instead of 31. And you know what? On a sentence-by-sentence basis, sometimes these things don't seem like such a big deal, but it's the cumulative effect throughout the document. It really adds to the flow of the document. So here are the edits. Again, admittedly, a little tense change there. They have admitted to, they admit. And my last little bit here before I turn the lectern over to Kim is, again, just, within reason, we want some confidence with some vivid, crisp language. And these are 2 examples that I found in those opinions that appealed to me. It's Posner. It's true that the sites, these are online gambling sites, by the way. It's true that the sites rake off some of the money in the pot, period. And that may not seem earth-shattering to you, but it's just really good, straightforward language. And I love that the vividness of the rake off some of the money in the pot. It's the word again, conversational, and of course clear. Now, Easterbrook's, but that's the very nature of compromise, period. Neither side gets everything it wants, period. I love that, the confidence to use 2 consecutive shorter sentences. Of course we need sentence length variety, but this is, again, just got a pop to it. Pop, 2 short sentences in a row. And, by the way, is there anything else that you've noticed here? Contractions. Ladies and gentlemen, we have here, if you trust our scholarship here, we have irrefutable proof that within the last year, the United States Court of Appeals for the 7th Circuit used contractions twice. And hold on. Yep, no, the earth is still spinning on its axis. The world did not end. The legal profession did not dissolve. We are not in anarchy. I don't know why lawyers get so uptight about the occasional contraction. And I thought I saw Making Your Case. Actually, I think a student over there has Making Your Case, Garner's book with Scalia. On that point of contractions, they had to agree to disagree and write separately. Because Scalia said it's too informal for legal writing. And Garner said, lighten up, people. So I'm in that camp. The occasional contraction, why do people use contractions? Because it helps them tighten up the prose, make it more crisp. And of course, the but at the beginning of the sentence, we'll get to that later. So anyway, I will turn over the podium to Kim.
I think what I want to just sort of highlight is the tips that we're going over today are really meant to focus you about the editing process, right? I think one of the hardest things for me as a writer is that I censor myself all the time when I'm writing because I don't want to make mistakes. I want to avoid nominalizations. I want to have crisp, clear sentence structure. And so one of the things that often prevents me from doing so is I'm scared of putting words down. So I want you to take a step back and think about the things that we're talking about right now as being things that you do at the very end process of your writing, right? After you've gone through the flowers paradigm of the madman and the architect and the builder, this is about being the judge, right? It's stepping back after you've done the majority of your writing, and this is the hard stuff, right? But we're giving you tips, like, tips that you can take and try to make your writing better, to make it crisper, to make it clearer, to make it easier and more enjoyable to read. So I'm going to talk about fun stuff, nominalizations, and why you should avoid them, right? And so maybe you don't know exactly what a nominalization is. A nominalization is itself, right? Nominalization is itself. A nominalization is when you take another, not a noun, but you take another part of speech, like a verb or an adjective, and you create a noun out of it, right? So that's what a nominalization is. So here are some examples, right? The verb intend. You can nominalize it by saying intention, right? You've made a noun out of a verb. Similarly, evolve becomes evolution. For example, distort becomes distortion. Discriminate becomes discrimination. Now, these are all perfectly lovely words, right? But they are nominalizations. An adjective into a noun. So, for example, applicable becomes applicability. Or difficult becomes difficulty, right? Again, perfectly lovely words, but you want to be cautious about when you are engaged in this process. Because oftentimes in the process of doing so and creating these nominalizations in our writing, what you're doing, the danger that you might face is twofold, right? Potentially one, you're hiding the actor, right? You're hiding the subject from your reader, right? You're not disclosing who's doing the action. And number two, you're often adding additional words, when part of what you want to do, like Mark said earlier, is make your writing cleaner, crisper, leaner, meaner, right? So let's see some examples. Here we go. I'll let you read that, because I know you know how to read. I want to point out the nominalization phrases in it, right? So here we go, right? We've got 3 extra long phrases to make this a 21-word sentence. Let's try our hand at editing this sentence, right? Getting rid of some of those nominalizations, creating a meaner and a leaner sentence that's easier to read, right? How about this? Let's take away some words. Let's just talk. The court concluded that the statute protects employees who are discriminated against because of their age, right? It's just making that long sentence a little bit more digestible. I'm going to pose. Right? Ready, easier for the reader to digest.
Can we cut who are?
Employees who are, what would you suggest, sir?
Nothing.
Okay, just take it out.
Discriminated against because of their age.
This protects employees who... The court concluded that the statute protects employees, discriminated against because of their age. Sure. Yeah, that's another great edit. Even better. We'll take that to 14 words from 16. Thank you. Okay, let's try another one. Well, how about your turn, right? Here we go. The Illinois statute provides for the imposition of criminal penalties. That's 10 words. Can we make it less than that? Can we have fewer words in that sentence? You know what? I think that Judge Posner might agree exactly with you, right? Look, you're emulating our honoree tonight. Now, that's just 6 words, right? We've almost cut that sentence in half. And we've also made it cleaner and crisper, right? We're taking out those nominalizations. How about another example? Any volunteers on this side of the room? These guys are really loud. Anybody over here? Yes.
We made the contention just to contends.
Exactly, right? Anything else?
Have a wish could be wanted.
And then into what?
Wanted.
Okay. Wanted, right? We can also, so let's see how Judge Easterbrook might rewrite this sentence, right? Fryer, by contrast, contended, exactly, that the organization's wish or want to be identified in this report, in his report. Great, right? We're taking that down from 18 words to 14. Okay. So that was a little brief tip about nominalizations, what they are if you didn't know, and how to get rid of them. What I really like is this idea from Helen Sword of the University of Auckland, who calls nominalizations zombie words. And she says because they cannibalize active verbs, right? A subject that Mark is going to address a little later. So just think of nominalizations as these zombie words, and you want to, Walking Dead, maybe kill them. Or, they're the undead. Anyway, now I want to talk about prepositions. Again, lovely little things, right? But oftentimes, if you use them too much, they're just, they get thrown around, and it's like having too much salt or too much pepper in your food, right? So, when you reach the stage, when you've finished writing, right, or finish the majority of your writing, and you're in that judge stage, when you're in editing mode, and trying to figure out ways to make your writing a little bit leaner, a little bit meaner, take a look at when you see of appear. Of is a great little word, very useful, but sometimes, can be overused, right? So take a look at those ofs. Do you need them? Do you need them in your writing, right? So let's see some examples of a little bit of an excessive use of the word of. So at the top, the opinion of the court was comprehensive. That's fine. There's nothing wrong with that, right? But how can we make it leaner? How can we make it meaner? Take out the of. Take out the of the, right? The court's opinion was comprehensive. An easy edit. The court published its opinion for purposes of guiding the bench and bar in future cases, right? Let's get rid of those prepositions. And we've got a leaner, meaner sentence there on the bottom, right? Replacing those 3 words with just that 1, 2. Just a couple more examples here, right? So the top, the verdict of the jury was supported by the evidence offered by the prosecution, right? Leaner and meaner. The jury verdict was supported by the prosecution's evidence. We've gotten rid of some of those prepositions, but what do we still have? We've still got the passive voice, right? Let's make it active. The prosecution's evidence supported the jury's verdict. Sound good, right? Exciting stuff. Let's get rid of some more ofs. Well, actually, let's just review what we were talking about. To avoid these needless prepositions, you might from time to time need to create a possessive, and that's all right, right? Changing the decision of the court into the court's decision. It's just like Mark was saying earlier. Using contractions, it's not necessarily a bad thing, right? Using the possessive, not a bad thing. Sometimes you might need to create an adjective, right? So, for example, a claim for defamation becomes a defamation claim. It cuts out just a couple words, right? Your turn. I like this interacted. So, the injunction entered by the district court is vacated. What might we do with that?
The district court's injunction is vacated.
All right, I like that. What about the bottom one? Some of the language of the magistrate judge suggests. Okay, so we're practicing putting the getting rid of the prepositions by making some possessives, right? And wouldn't you know it, that's what Judge Easterbrook might have done, actually did do, right? There we go, the district court's injunction, the magistrate judge's language. Let's see one more example from Judge Posner. Now, this isn't what Judge Posner wrote, but let's fix it like we were Judge Posner. The courts of Illinois are reluctant to imply a private right. There we go. And that's exactly how Judge Posner wrote it. Ready, Mark?
I'm ready.
Okay.
I'm ready. Yeah. All right, I'm going to pick up the pace. I knew I'd go on too long about plain language. Sorry. Passive voice. Why is 1055 up there? Well, if you did a Westlaw search, Lexa search, and put passive voice in quotation marks, that's how many court cases say passive voice and are considering passive voice. So I think we lawyers should know what passive voice means if there's over 1,000 court decisions talking about passive voice. And we also heard a judge talk about avoiding the passive voice. There are times where passive voice will be just fine. The first thing we need to figure out, though, is what the heck is it? What is passive voice? Is that something to do with tense? Is that like past tense, passive voice? Nothing to do with tense at all. And it also has nothing to do with what the verb is. You know, if I describe something, somebody acted timidly, that doesn't make it passive. We're talking about the arrangement of words syntax. We're talking about the arrangement of words in the sentence. So here we go. The motion was granted by the court. Who or what is the actor in that sentence? The court. What's the action? Granted. Why is the actor stuck at the end of the sentence after the action, like a second-class citizen?
Translated from Japanese.
So active voice is really about getting the actor, or if it's not a real person, a logical agent, but I just say the actor to keep it simple. Getting the actor up front in front of the action word. And generally it leads to much crisper prose. It can avoid wordiness. And it also does something else. Sometimes when you write in the passive voice, what happened here? Who's the actor? The court, but it's implicit. There's no explicit actor at all. Now, not a big deal here, because context would resolve the ambiguity, and we know who grants motions, courts do. But that would make it absolutely clear for any of you future contract drafters and legislative drafters, think about something like that, because this is the type of thing that can happen if we begin to lapse into the passive voice as a habit. All common areas must be kept in reasonable repair. Well, that sounds perfect. It's a nice short sentence. What could be wrong with that? Who's got the legal duty? So that's right. Yeah, the other guy does. Exactly. Who drafted it? We'll construe that against the drafter. So anyway, that's the power of active voice, really kind of in a substantive way for us lawyers. We want to make it clear who's got the legal duty here. So let's look at a few quick examples. This form of speech is protected by the First Amendment. What is the actor there? The First Amendment, and it's protecting. So the First Amendment protects good, crisp prose, active voice as a preference. Again, you're not going to worry about this all the time. Your turn. Anybody else want to take it? He's too good. He's jumping right in. So criminal penalty. Who's the actor there, or what is the actor? Statutes. What's the action word? Okay. Why is the actor after the action? How would Judge Posner write it? He'd write it like this. An Illinois statute imposes criminal penalties. Now we're down to 20 words. Another one. Who are the actors? The parties. What's the action? Agreed. Why are the actors kind of taking up the end of the train there after the action? Let's do it the way Judge Easterbrook did it in his opinion. The parties agreed. Note that active voice doesn't literally mean you have to begin your sentences with the actor. It's looking at the main clause. Here we have a perfectly healthy, happy introductory element before the main clause here. But at the beginning of the main clause, actor doing action. So you can see the comparison. Just that edit really tightens up the prose there. Really, really tightens it up. All right, so now we'll do a quick change of topic. I just like that picture. There's no purpose for it at all. Actually, okay, we want to get into some rule breaking here. Okay, let's break some rules. What do all of these writers and literate publications have in common? A lot of things, probably. But they are all perfectly comfortable with. They all routinely begin sentences with coordinating conjunctions like but and others as well, yet and so, and all the fanboys' words. But and, everybody has this, your fourth grade teacher said you can't do it. That's about the only thing we remember about our education. And I really, could just say every accomplished writer in the English language is what I could have written up there, but I thought this would be more entertaining. But wait a second, legal writing is really formal. Legal writing is really weighty stuff. We're talking about rights and liberty and all kinds of important weighty topics. So lawyers, we can't do that. This but and stuff at the beginning is way too casual for us lawyers to do. It can't be done in legal writing. Absolutely out of bounds. What respectable legal writing would begin sentences with but and? Well, let's think about U.S. Supreme Court opinions. I dare you to find me one. Email me if you can do this. Find me a single U.S. Supreme Court opinion that does not have sentences beginning with but and. And you won't be able to do it. It'll be hard to do, I'll say that. All of the justices, current justices, I've researched this. I'm a nerd, people. I think it's exciting. Use but and to begin a sentence. But surely that's just some renegade U.S. Supreme Court justices. No other respectable, important legal writing would do that. I mean, again, important thing, or maybe the U.S. Constitution does it, and maybe Thomas Jefferson got out his but and to start sentences in the Declaration of Independence, and that is not a very long document. And you still see a couple of them here. But would our award winners, our honorees tonight do that? I can't believe it. I can't believe that these Lifetime Achievement Award winners for Scribes would dare to begin sentences with but or and. This is just the one opinion that I happened to pull up. Of course you do it. Of course you do it. If you want to be an effective, excellent writer, this is good stuff. It adds cohesion. It helps you mark a quick, immediate contrast with the word but. It immediately signals to the reader that the next idea is going to contrast with the one that came before it. This is good stuff, people. Do it. Break the rule. And I think we're now on to the next one. Okay.
So just like you may have learned from your first or second grade teacher that you are not allowed to start sentences with but or and Mark has provided good reasons why you can, you may have learned from your sixth grade composition teacher that you're not allowed to have a one-sentence paragraph, right? And I'm here to tell you you can. So let's see an example, right? You can, and often to good effect, right? So take a look at this these paragraphs here. So I'll draw your attention to the one-sentence paragraph in red, right? What does it do? What purpose does it serve in this set of paragraphs, in the storytelling of this narrative, right? When you read that first paragraph, it sounds like terrible, doesn't it? It sounds like the author is in this terrible place. And then you get to that one sentence paragraph that shifts the entire tone. And she tells you, I couldn't have been happier. I couldn't have been happier. Despite all of these things, right? I couldn't have been happier. And I'm ready to go. And that paragraph goes on for a little bit longer than what you see, right? And we, as legal writers, can also employ this technique in order to tell a story, or really to tell a better story, right? To make the story more interesting, to make it more dynamic. Well, here's an example from a real brief, right? Not a work of literature, but something that came from a real brief. When you're telling the court about the facts giving rise to the litigation, right, or the problem, you want to tell a story. You want to involve the reader, the court, the judge in getting to know what's happening, what's important, what's relevant. But you don't want to bore your reader, right? They're using sparingly, right, a one-sentence paragraph to signal some shift or some change in the timeline or narrative can be very effective. Everything was going great for the Berger and the Katzes, right? Until Mr. Berger got sick. And we know that something happens there. We want to read further. Because we're talking about breaking rules, I love this metaphor, right? Mark's metaphor here. Always apply the chocolate milkshake test. I see that Mark over there is talking to Mark, and he's telling him to hurry up because everybody wants cocktails. I'm almost done. The chocolate milkshake test. When you break rules, it feels good, right? But sometimes, let's just think about having that chocolate milkshake, maybe in the middle of the day, maybe before you've had any real food. It might taste great, but you don't want to do it too much, right? You don't want to overindulge. 2 chocolate milkshakes in the same paragraph on the same page may not look or feel very good. So just keep that in mind. Break the rules sparingly, but be able to break rules or allow yourself to break rules. And I think Mark might have something to say to us.
Okay, there we go. All right, one punctuation rule, I couldn't help myself. All right. You know, people think of punctuation as just something you use to get it right. But if you really get to know the punctuation rules, they can empower you to make an impact on your reader. And I just chose a colon. And the general rule, of course, is you're supposed to have a complete sentence in front of the colon. People break it for style, yes, but you should have a complete sentence that logically points to what comes after it. Anything can come after it, a single word, a series, or another complete sentence. But once in a while, don't forget about the colon. It can make add a little pop to your writing, a little bit of pop. The bylaws had a glaring flaw, colon. They failed to provide for meetings. The court decided one issue, colon. Jurisdiction. There was one reason for the bank's failure, greed. You compare these two. Little artistic license there, with the second one. But once in a while, by the way, did you notice Judge Ross's favorite sentence ever? The one about the Iowa bombing? Yeah. It used this technique. I wish we could put his back up there, but we can't. It said, blah, 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 colon, boom. And it had a great ring to it, didn't it? It was a really, really good sentence. So think about this. Think of punctuation as your friend as a writer. Get to know it, and you can use it to make an impact. Again, you have to, if you do that technique, it's noticeable. So again, that second milkshake doesn't taste so good. And the third one makes you puke. So keep it under control. Some bonus tips. Don't do all caps. And you law students are way ahead of my generation on this stuff. You're like, why is somebody yelling at me? Thank you so much for your time and attention. Enjoy the reception.